This week on The Sceptic, I speak to Peter Hitchens, author and columnist at the Mail on Sunday, on the latest development in the Lucy Letby case.
The fact remains that the prosecution's case has now been seriously questioned by people very well qualified to question it. This is pure, disinterested thirst for justice. If she's not guilty, that is so frightful, so disgusting, and so intolerable that I don't see how any person of conscience can continue to ignore it.
If anything happens to our little ones, we will hold you personally responsible. It's down to our council and our politicians and our police to keep us safe. And if they're not doing their job, we will do the job.
Barrister Adam King on his client with the Free Speech Union, former Royal Marine Jamie Michael, being found not guilty of stirring up racial hatred, and what that says about the government's post-Southport crackdown.
Stirring up racial hatred is quite a broad and vague concept. The threshold for prosecuting under that offence has become much lower, and we're now seeing people being prosecuted for things that get said a lot by reasonable people, including politicians and so on.
And for our premium subscribers, I speak to pseudonymous author Eugippius on the chaos in German politics after the fall of the German establishment party's cordon sanitaire against the AfD.
Major analysts are saying this, even people inside the CDU are saying this. If they can't find a way to turn around migration politics, AfD is going to be a 30% party in 2029. So they're going to be the biggest party, and CDU is going to switch places with them and going to be in the mid-20s, low 20s by then.
If you're not already a donor, make a donation of at least £5 a month to the Daily Sceptic, log in with the same email, and you'll find a link to the premium version of the podcast on the homepage, including instructions about how to listen to it on your favourite podcasting app. Donors will also be able to access articles behind our paywall and join our discussion threads on Discord, where you'll have an opportunity to discuss the latest Daily Sceptic content with other donors, members of the editorial team, and some of your favourite contributors. You can access all this bonus content for as little as £5 a month. Just go to dailyskeptic.org/donate. Now, on with the show. Hello and welcome to episode 28 of The Sceptic, the Daily Sceptic's weekly podcast. I'm your host, Laurie Wastell, an associate editor at the Daily Sceptic. There were no murders. So said Dr. Shu Li last week, as the head of an international panel of 14 eminent neonatologists and medical experts tasked by MP David Davis with assessing the medical evidence around the Lucy Letby case. Its conclusions have thrown significant further doubt on the guilt of the 35-year-old neonatal nurse currently serving 15 whole-life orders for the murder of 7 babies and the attempted murder of 7 more at the Countess of Chester Hospital in 2015 and 2016. Rather than malfeasance, it was the view of Dr. Li that the tragic deaths were the result, principally, of substandard care. If the struggling ward had been operating in his native Canada, he said, it would have been shut down. So could this be one of the worst miscarriages of justice in British legal history? Well, to discuss that, I'm very pleased to be joined by Peter Hitchens, columnist at the Mail on Sunday and the author of several books, including The Abolition of Britain. Welcome to The Sceptic, Peter.
Well, it's a pleasure to be with you, so far at least.
Good to have you here. Okay, so this case has been going on for quite a long time, and I think it's easy to lose sight of the fact that, back in mid-2023 when this case was tried and she was convicted, there was, people were generally pretty certain that she was guilty, and of course there was, coverage in the press about her being evil and understandably trying to sort of understand how someone could possibly have done something so appalling. And but bit by bit, doubt has started to creep in over, with reporting and other things. And I suppose my question for you, first of all, is when did you first having concerns about the safety of this verdict, and how much more so concerned are you now?
Well, the first thing that concerned me wasn't the safety of the verdicts. While the trial was still going on, there was an exchange between one of the prosecuting barristers and Miss Letby in which he said to her, "Why aren't you crying about these children? You cry for yourself." And I found this in some strange way repellent and worrying, because I have had for most of my life a very strong belief in the probity and rectitude of English justice. And I've had in my mind two fictional accounts of the behaviour of judges and lawyers in court. One, I think, in Strong Poison by Dorothy L. Sayers, in which I think her heroine, Harriet Vane, is at one point on trial. And the other, an extraordinary fictionalization of the of the Hindley and Brady trial in C.P. Snow's book, The Sleep of Reason. Now, the thing about both of those is and it also is something I experienced when I was setting out as a reporter back in the 1970s, was the dispassionate nature of justice in an English courtroom. People were not trying to prosecute through emotion. The crime itself was serious, and if you were convicted of it, then serious things would happen to you. But there wasn't a desire to whip up emotion, rather the contrary. And there was a strong feeling of reason being in charge. And then I've met quite a lot of barristers. I know what kind of people they are. And I've met quite a lot of nurses, and I know what kind of people they are. Miss Letby was the accused, not the convicted person. There seemed to be something wrong with this treatment of somebody who'd gone into the witness box as a defendant, which is quite a rare thing anyway. Defendants are not encouraged by their lawyers to go into the witness box, being spoken to in this fashion. I didn't like it. And I began after that to look a little bit more at a trial which had basically been going on in the background for me. I hadn't been concentrating on it as I should have been. And then after it was over, and after again, there was the extraordinary emotional nature, if you'll remember, of the sentencing procedure and her failure to appear or refusal to turn up or whatever it was. And again, there seemed to be something about it that was more emotional than rational. And then things began to appear on the internet from people who didn't seem to me to be out of their minds, saying there was something wrong with the statistics, and there was something wrong with the whole, as it were, creation of an atmosphere of guilt. And there appeared also to me to be a distinct lack of hard evidence. And at that point, shortly before the second trial began, I wrote an article in the Mail on Sunday, very reluctantly, because I'd been involved, and I'm still involved in other miscarriage of justice activities. And I know that it's quite a hard thing to take on. Once you've committed yourself, you're stuck with it. And you have to keep on doing it until it comes to whatever it comes to. And it consumes a great deal of your energy and of your time. And I really didn't feel that I'm not a statistician. I'm absolutely not a medical expert of the kind who so badly needed in this case. But there was something in my bones which said, this isn't quite right. And the more I saw, the more I looked into it, the more it seemed to me. And so I wrote a speculative piece saying, I really wished it wasn't me, but I just feel that it's possible that this woman may not be guilty. Now, given that under English law, our rule is that if someone isn't convicted beyond reasonable doubt, then they can't be convicted. If there is reasonable doubt, then it's not in there. This seemed to me to be important. And there was also something profoundly unlikely to me about what was being alleged. And no one could ever come up with any motive. There was absolutely no history in Miss Letby's life suggesting that she was the kind of person who wanted to kill babies. And the method being alleged looked extraordinarily contracted. If you know, I mean, I'm not a medical expert. There just seemed to be something incredibly elaborate about it. And so I just thought, I've got to say this. Since I feel it, since I think it, I've got to say it. And I work for a newspaper where the editor gives me an immense amount of freedom to say things which are unpopular, which he himself may not agree with. It's not, he doesn't care whether something is something he agrees with or not. He's an editor of great understanding of what editors need to do, and if he thinks something is interesting and worth saying and is well put, then it's his view that generally he will print it. And so I was able to do this, and I knew I don't want to build myself up here, but I knew that if any significant, well-known commentator on a national newspaper said this, that it would make it easier for the case to be reopened ultimately. It wouldn't clinch it. Nothing clinches it, but I knew that therefore I was taking responsibility. And I thought no harm, and I still think no harm, could possibly be done by the case being reopened and re-examined. If it turns out that under the kind of strict scrutiny which it's now receiving, that a court can still be persuaded that she's guilty, then that's it, really. But if, on the other hand, it doesn't turn out like that, then it's vitally important that something is done. You can't send somebody to prison until they die and not expect, if there is any doubt about it, and not expect some efforts to reopen it. And it's very interesting. David Davis said this the other day, and I think he was absolutely right, that when people were condemned to death, huge amounts of efforts were actually attempted to be put in to investigating whether they merited a reprieve. And I think if they appealed, there was never any question of being granted an appeal. A lot of people think Lucy Letby has appealed and has failed, but she hasn't. What she's done is she's tried twice to obtain leave to appeal and has been refused it. The case has not been heard, which seems to me to be quite shocking given the severity of the sentence and the importance of the case. So her appeal remains unheard. And that seems to me to be just plain wrong when the crime is of such moment and the punishment so stringent.
And so just to pick up on one thing you said earlier there, so you described an atmosphere of guilt pervading the first trial. And of course, we hear a lot at the moment about the importance of not being in contempt of court so that trials are fair. But an atmosphere of guilt, that's precisely what you wouldn't want there to be for justice not to be prejudiced, right?
Well, yeah, I think there is the presumption of innocence is often a bit of a fiction in reality once someone is put in court. And I'm very much among those people who think that we should abolish the dock and the defendant should sit with his or her lawyers in the middle of the court rather than in a box surrounded by guards, except in very exceptional circumstances where it might be justified. But the whole procedure does tend to presume guilt by implication. But I had thought, again, I looked up the bizarre business of her. She was arrested 3 times, and only on the third arrest was she actually charged. After the first arrest, while she was in custody, officers were sent to dig up her garden, and somehow or other, I know not how, the media found out that this was going on. And then there were the thing which continues to amaze me. I say it to people, and they're not as amazed as I am, but I just think it's really, really strange. Is I think 9 of the prosecution witnesses were granted anonymity. This is unknown outside treason and spy trials. And of course, there's rape trials and that sort of trial where the accuser is granted lifelong anonymity. Witnesses granted anonymity for the prosecution. Can this be right? Can open justice take place when this is going on? And I thought, why? Why is this so? And I still do. There's something off about it to me. That there's a huge, great cloud of, of a particular kind of concern already hung over the courtroom before the first evidence was heard.
And meanwhile, David Davis has said that there were nurses who wanted to testify on her behalf, but who were too afraid to and were in fact warned not to.
I think that's quite credible. I mean, I haven't spoken to anyone in that position, but I don't find it surprising, particularly if you were in that part of the country at that time. I think there was an atmosphere about which made the presumption of innocence not a wholly dead letter, but certainly much weaker than it should have been.
Okay, so there's been an enormous amount of interest in this, of course, but the latest development is obviously this panel of international experts with Dr. Shu Lee at its head. And so you were there at that press conference last week. What struck you most about it, and how significant is it?
Well, it's the disinterested nature of it, really. Dr. Lee himself really only discovered about the case after it had taken place and was when he was asked to take part in the original plea for leave to appeal. And this was just pretty much banged back by the Court of Appeals in not having it, even though he'd actually demonstrated, I think, that the whole idea of air embolism as a means of murder was questionable, and also that the claims that air embolism had certain identifiable symptoms in skin discoloration was a misunderstanding of his own paper. But the attitude of the judges appeared to me to be, at least this is part of what they said, that if the defence had this information, why didn't they put it forward at the trial? Well, that's a jolly good argument about procedure and about the rightness or wrongness of the construction of the defence case. But it seems to me, as I say, to be completely without any element of justice in it. If there is evidence which suggests that the defendant might not be guilty, then surely It doesn't matter what the circumstances are which prevented it from being heard in the first place or whose fault it is. Surely the courts should be interested in hearing it. I just can't see any answer to that. Why it doesn't appeal? And I believe that the appeal court, I think my old friend and colleague David Rose has made this point. Not all that long ago, the appeal court didn't used to make this kind of stringent refusal. It would accept evidence which might have been presented at the original trial. But they now seem to have made it a sort of rule that they won't do it. I think that's ultimately ridiculous. What is the purpose of the courts? It's not to pursue procedure, it's to obtain justice.
I suppose one of the arguments that's made on this is that a new expert opinion on already existing evidence doesn't actually count as new evidence. What do you make of that?
I don't really know what it means. If it's something new, which is the result of genuine expertise and relevant to the case, which the jury didn't hear, then that means the jury should have heard it, and any future tribunal on this should hear it too. It's technicality and excuse making. I just don't think that it works for me. The purpose of courts is ultimately justice. I quite understand why the courts are unwilling to overturn jury verdicts. And the appeal court, the criminal appeal court, took a very long time to be established because judges said, well, hang on a minute, surely jury verdicts are sacrosanct. We can't overturn them, nor should anybody else be able to. And there's some strength in that. But it's not enough if you've got somebody who's sitting in prison at the age of 35 who's been told she's going to die in prison and about whose guilt there are now more doubts than there were at the time she was tried. Isn't it then evident that through simple natural justice that there ought to be a re-examination of the case? I just don't see an argument against it. And again, what harm does it do to re-examine the case? Who is hurt by it?
I suppose one of the ways that the conclusions of this panel have been criticised is to say that, well, yes, these were people with great expertise, clearly, but the defence didn't call their own experts for whatever reason, but the prosecution did, and those were also experts in their field. So why should one give particular weight to the conclusions of Dr. Xu Li et al. Over and above those of the prosecution experts? Or what do you say to that?
But the Xu Li press conference wasn't a gathering of a court to decide whether or not Miss Letby should be released. It had no such power. All it can do is ask for the next stage, which is, as I say, a reopening in some form, either at the Court of Appeal or in the form of a renewed actual criminal trial before a jury, I don't know which, of the case. And the supporters of a re-examination of the case, those who think the verdict is unsafe, don't propose to march upon Bronzefield Prison with pitchforks and forcibly release Miss Letby. What we actually want is for the legal system to act as it should when faced with what may have been a very, very severe miscarriage of justice. If we're going to have somebody locked up in prison until she dies, then we need to know that she ought to be there. And the question is not, as has been rightly pointed out, the question is not, is Lucy Letby innocent? Nobody except her can know this. The question is she guilty? Has it been satisfactorily established, according to English law, that she's guilty? And it's no point going around having recriminations about the character and quality of the defence and all the rest of it. It doesn't matter. I don't care about it. I'm completely uninterested in that. So the question is she guilty? Is there evidence beyond reasonable doubt to show that she is guilty of the terrible crimes of which she has been accused and convicted? I think there isn't. I think there is really, really enormously serious doubt. And the point about the quality of Dr. Xu Li's panel is not just that they're immensely eminent people, and one would like to see them. I would like to see them contesting this case with the experts which the Crown provided at the last trial. I'd be interested to witness that. The point is also that these people are acting completely dispassionately and without any commitment. They agreed at the beginning with Miss Letby, as I understand it, whatever they came up with would be published, whether it was favourable to her or not. They have no stake in this at all, any of them. None of them have been paid a penny. Dr. Li flew to London at his own expense from Alberta and stayed there at his own expense. No one paid him to come and be there. This is pure disinterested thirst for justice. And confronted with that on the part of a significant number of some of the most eminent doctors in the necessary fields in the world, it just seems to me to be ridiculous to say, oh, well, thanks for coming, guys. She stays in prison and we don't want to listen to you. Let them make their point in court, and let us see that what they say contested against, as it wasn't in the original trial, contested against what the prosecution experts said. We know that the defence counsel questioned the prosecution case a lot, but what a lot of people don't seem to grasp is this is not evidence and can't be taken into account with a jury. If you want evidence, then you have to have an expert, and the defence's expert mysteriously was not called. He believes, and has told Judith Moritz and Jonathan Coffey in their excellent book with a very bad title, Lucy Letby Unmasked, he's told them he thinks her trial was unfair. And he saw almost every hour of it. He missed a tiny bit, but he was generally there for the whole thing. He thinks it was an unfair trial. She did not get a fair trial. Well, he is a doctor of some eminence in his field. If he thinks that, then we need to listen to it. You don't have to listen to me. I'm irrelevant in all this. I'm just a scribbler. But you do have to listen to the people whose actions and statements I report on.
Yeah, and so you make the point that many of these experts are indeed disinterested and eminent. But one of the claims...
Well, all of them are disinterested, as far as I know. And all of them, my understanding of it, because we were presented with their life stories and their qualifications and their experience, my understanding of their abilities in this field is that it's considerable. And what's more, it wasn't as if some of them said, no, actually she's guilty. They all came out with the view that no crimes have been committed.
But despite that, one of the claims that's often been levelled at the Letby might be innocent side of the debate is that they're conspiracy theorists, or getting on that way for wanting to believe, or being sort of motivated in some way to believe this. I mean, what do you make of that?
Well, again, there are people who support the verdict and they're entitled to their opinions, and they can be as rude about me as they like, though they have no knowledge of my internal mind or of my secret heart. They don't know what's engaging me. They can come up with all kinds of things. It pleases them, but it's irrelevant. The fact remains that the prosecution's case has now been seriously questioned by people very well qualified to question it over and over and over again, and to such an extent that I think for the public's peace of mind, I don't know how you feel or think about this, but if you have knowledge in your own life of somebody suffering needlessly who you might be able to assist, then you will assist them, won't you? It doesn't matter if people call me a conspiracy theorist, whatever that means. I mean, this country is full of what if conspiracy is people getting together in private to pursue a common agreed end without people knowing what they're up to, then this happens 20 times a day around the restaurants of Westminster, and it's called lunch. But I don't engage in anything of that kind. I don't know and I have no theories about why other people have. I don't believe the trial was a conspiracy. I don't know why a conspiracy theorist is basically just a stupid playground insult designed to avoid reason and logic. I don't see why anyone should take it. If they haven't got anything better to throw at me than to call me a conspiracy theorist, then they obviously haven't got anything. And what else have they got? That is just remains the problem. What else have they got? What is it that they've got? Why are they so against it coming back into court if they're so confident that they're right?
So one of the arguments that's sometimes put forward by the alleged conspiracy theorist side of the debate is that a subconscious or some kind of a desire to protect either the reputations of the specific doctors involved, some of whom were accusing Letby, or the NHS in general, played a role in her conviction. And this is derided by people on the other side as a conspiracy theory itself. But what do you make of that? I mean, did the desire to protect the NHS play any role here?
I'm not interested in it. I'm just not interested in it. What I'm interested in is whether Miss Letby's conviction is safe. I'm not interested in recriminations towards anybody in this case. I think that my sole purpose is to ensure that she gets the fair trial, which she didn't get, in my view, at Manchester Crown Court, and that both sides of the case are properly heard, and that if she turns out as a result of that not to be not to be considered guilty by the legal system, then I think she should be free. And if it turns out in a proper trial in which both sides are heard that she is guilty, then obviously she stays where she is. I can do no more than that. But at the moment, everything that I see suggests to me that the conviction is unsafe, and that she was not convicted beyond reasonable doubt, and therefore it should be reopened.
And of course, the question is whether the Criminal Case Review Commission will now take this up. And do you have a sense of what might happen there? I mean, will it be a retrial, also taking 10 months?
No idea. The CCRC has the power, I think, to instruct the appeal court to hear it. The appeal court, I think, and forgive me, I am not a lawyer, I think would have the power either to hear the case and to quash the conviction itself if it wished to, or to order a retrial. So I think those options are open. Given the immense length of the original trial, I suppose there would be a reluctance to order a retrial. But again, the issue being so big, we can't. It's not for me to say. I don't mind. It's not. It's as long as her case appears before the courts with a proper defence, then I don't mind. It's not my business. All I wish to do, and all I've ever wished to do from the start, is to point out that there appears here to have been a miscarriage of justice. Somebody may be in prison till she dies for an offence which she may not have committed. That has to be a matter of concern to any civilised person, and the best way of sorting it out is for it to go before the courts again. We have facilities for this. We have appeal courts. That's what they're for.
And so what's the significance of this for the Thirlwall inquiry then? And in particular, its dismissal of questions over Letby's innocence as just so much noise.
Well, I think the Thirlwall inquiry is ridiculous. It's absurd. It starts out with a presumption that there is one explanation for these events, and therefore, how can it find anything out? Once they have decided that Miss Letby is guilty, then everything that they then examine has to revolve around the presumption that Miss Letby is guilty. It's very interesting, I thought, when her new barrister, Mark MacDonald, asked to have representation rights for her at the Thirlwall inquiry, he was told, no, you can't have them. So what sort of tribunal is that? I don't. If you close your mind to one possibility, totally close your mind to one possibility that she isn't guilty, then how can you possibly examine the case adequately? It's absurd. I should be glad when it's over.
Fair enough. And I suppose we haven't really got much into the evidence today, which is more like talking about issues around this. But from the panel, is there any particular bit of evidence that you heard that stands out?
No, here's the point. That anybody who begins to study this very quickly discovers, with a great sense of shock, good heavens, there was never at any stage any evidence that Miss Letby had ever harmed anybody. There just isn't any. There never has been. And that is, if anybody who looks into it, begins to look into it, and whenever anybody says to me, well, she's guilty, I say, all right then, it's a very simple request. I provide me with one objective piece of evidence of her harming anybody, and nobody can, because there isn't any. There never has been. And do you not find that surprising? And people will say, yes, of course you can convict on circumstantial evidence, but again, so what? What is this circumstantial evidence that's so compelling? I'm not compelled by it.
Well, so I mean, many people will point to the note she made, and as you say, the fact that she was not crying in court.
Well, they will, but you will. But as you say that, you know the answer to it. But these are the scribblings of a distraught woman, probably heavily medicated on antidepressants at the time she wrote it, and as one has now since heard, being asked to write out her thoughts by some sort of therapist. And in any case, she has never at any stage, at any point, shifted from her absolute denial of having committed any offence. So to turn this into a confession of guilt, it's just not, it's not evidence. I don't think any serious English court would ever accept it as evidence of guilt. It's in the same class as the great chart showing that she was on duty for all the deaths. I mean, all that chart shows is that she was on duty. That doesn't show anything else. And then this amazing insulin accusation, but no one has any evidence at all that Miss Letby did anything with insulin at all. There isn't any. It's pure supposition. And then when you get this panel of experts coming and saying, well, actually, we can't find any evidence that there was a crime at all, that tends to chime with the absence of evidence that Miss Letby committed it.
And so finally, obviously, you think there should be a retrial or something like it.
The case should be reopened in such a way that if she isn't guilty under English law, she shouldn't be in prison. If she is, then she should. I know that we have to accept that. That's the way it goes. But at the moment, I don't think sufficient evidence has been brought before the courts to establish that she's guilty beyond reasonable doubt. And you look at it, even the Economist, the voice of the establishment, is now accepting that there could be something wrong with the case. Joshua Rosenberg, an eminent legal commentator, is beginning to, who's very much, how should one say, an establishment voice, is beginning to write as if there might be some problem. The work of the campaign to reopen the case has made a great deal of progress with serious minds, which is where it has to make progress of this kind, and I think that gives an indication.
But so in terms of the timescale of this, so with Andrew Malkinson, there was evidence, DNA evidence, potentially exonerating him after only 4 years, and yet it was 17 years in prison that he spent before finally being freed. And so, well, for Letby, do you have a sense of what the timescale of this might be?
I have no idea. I mean, I'm, as you possibly know, not an optimist by nature. So I would not be surprised if it took 10 years. I would be appalled, but I would not be surprised. It is immensely, ludicrously slow. If I had anything to do with government, or if I were a multi-billionaire, I think I might spend a great deal of money on trying to establish a far more effective body to investigate potential miscarriages of justice. There are many which will never make it into the newspapers, which still desperately need to be righted. There's a whole database at the University of Exeter which shows a shocking number of miscarriages of justice in this country. And part of the problem which people have with this, and have had from the start and will continue to have to the end, is we really do wish to believe that there is a fair justice system in this country. Against repeated evidence, whether it's the Malkinson case or the post office scandal recently, that this isn't so. And that's why we resist so strongly when anybody says, oh, there's something wrong here. Oh, no, not another one. And what can one do? But it could be 10 years, and by which time her life, already blasted by woe, will be almost completely devastated. And you can't, lost time, years eaten by the locust, cannot be restored by any amount of compensation. It's gone, and a whole peace of mind and capacity to live normally has gone. If she's not guilty, that is so frightful, so disgusting, and so intolerable that I don't see how any person of conscience can continue to ignore it. If she is guilty, well then, let us find out that she is, because I don't think we have so far.
Indeed. Okay, well, Peter Hitchens, thank you very much for coming on The Sceptic.
Thank you for having me.
Now, last week, former Royal Marine Jamie Michael was found not guilty of stirring up racial hatred for a 12-minute video he posted shortly after the Southport attack last summer, in which he called for community action to prevent such atrocities happening in the Welsh valleys, where he lives. It took a jury at Merthyr Crown Court just 17 minutes to acquit the father of two, who had been reported to police by the office of a Labour member of the Senedd called Buffy Williams. So a huge victory for free speech. But the question many will be asking is, why was he, and many like him, ever charged in the first place? Well, to discuss that, I'm very pleased to be joined by Adam King, who was his barrister with the Free Speech Union. Welcome to The Sceptic, Adam.
Hello, very pleased to be here.
Yeah, good to have you here. Okay, so the trial is over. It's a not guilty verdict, so congratulations. But so to start with, well, what were your expectations going into this trial? I mean, did you think you were going to win?
Yes, I was pretty confident we would win. One's always wary of being overconfident. Anything can happen in a jury trial. But I felt this was a very weak case from the Crown's point of view, and I thought we were going to win. I'd heard that some similar cases that friends of mine had been involved with had been dealt with a degree of hostility from the bench, and I didn't know what I was going to get on that score. And I was very pleased to find that we had a very decent, fair judge, which is a lovely thing in any trial. And it was prosecuted in a very sensible way. The advocate on the other side, likewise. So the win was in our favour, at least, or at least not against us on that front.
Okay, so of course the particular charge was stirring up racial hatred here, and this was for this 12-minute video that he posted shortly after the Southport attack. And so tell us, what were the key points of contention in that video? Well,
I mean, like any extempore to camera bit that anyone does, there are going to be, ambiguities and aspects where things could be clearer, right? And he used a couple of sort of, offensive seeming phrases, fucking psychopaths, scumbags. That was pretty much it. And, this seems to have been interpreted by the other side as referring to foreigners in general, migrants, illegal migrants in general, that kind of thing. It seemed to me pretty obvious that what he was talking about when he was using those sorts of phrases was people like Axel Rudikabana, people who do or would or would murder children or commit similar sorts of atrocities. And so it was really only on a very ungenerous interpretation, in my view, that you could take that video as a whole and say that that was something that was likely to stir up racial hatred.
And so you were able to set out that distinction quite convincingly in court?
Yes, I was. I mean, to a large extent, the video spoke for itself, but that was certainly one of the big points we were hitting during the trial. Jamie himself, you never know what a client's going to be like till you meet them, and some come across better than others, of course. Jamie's a very peaceful man who comes across well, and that further led me to think that we would be successful. I mean, the video was what he was saying had various different aspects. One, perhaps the theme of it, was wanting to get together with other people who were concerned about these sorts of attacks happening in future, the connection between that sort of thing and immigration, and he was particularly talking about illegal immigration, getting people together to go to politicians, councillors, local MPs, the police, and he specifically said those three categories of people 2-3 times in the video. He said, I'm not talking about getting bats and knives or anything like that. He was quite specifically non-violent about it. It was quite clearly an expression of a political view, sentiment, and so it attracted the protections of Article 10 of the ECHR in a big way. There's a recent case on that, domestic case called Casserly, which was an allegation under Section 1 of the Malicious Communications Act 1988, grossly offensive being one of the key phrases in that statute, in that section, which is slightly different from the stirring up racial hatred offence, which is insulting, threatening, or abusive words, images, sounds. But they're similar offences in some respects, and the Court of Appeal in the case of Casserly held that Article 10 was very much engaged, and that a Crown Court judge should sum up to the jury in a way that highlights the considerations that Article 10 requires to be brought to the fore. And our judge did exactly that.
Right, that's good. But one point that's been made here is that it's almost a shame that you say you had to rely on a particular bit of case law to remind people of the importance of that Article 10 free speech protection, when really, legally speaking, shouldn't there already be a big presumption in favour of free speech?
Yes, well, I mean, there is a presumption of free speech, legally speaking, very much. Indeed, the case of Casserly made clear that the common law, the English common law, and the rights conferred by Article 10 of the ECHR are largely, if not entirely, coextensive, right? So, arguably, you don't need Article 10 because the common law reflects that. But Article 10 is a useful mechanism through which to apply these pieces of law. So yes, the law absolutely does protect free speech. It has particular emphasis on political speech, which Jamie Michaels was, and also was the case in Casserly. It's said to be the apex. I think it's a case called Connolly, where it was put in that way, that the political speech is at the apex of the hierarchy of free speech protections. The difficulty in a criminal trial here, whether that's in the Magistrates' Court or even in the Crown Court, is that those courts are not always that used to dealing with and applying the case law from the European Court of Human Rights or the domestic case law relating to Article 10, right? One area in which it has been applied many times recently, and controversially in some ways, is the protester cases, the Just Stop Oil cases. And the Supreme Court found in a case called Ziegler, I never know how to pronounce it, I think in 2018, thereabouts, that said in passing, I think, but it's been, very much taken on board by the protest side of things, that a jury can even be asked to conduct a proportionality exercise in assessing whether a conviction would be a proportional response in light of the case law around Article 10. So the basic point is, it's not always easy to inject the force of the law around Article 10 and the common law free speech rights in a practical way into a Crown Court trial. You can make an abuse application at the start of the thing, and you can say this case needs to be stopped before it's even started. That's very difficult. You can argue it at half time after the close of the prosecution case and say this case needs to be stopped at that point for Article 10 type reasons. And failing that, you can argue to the judge that he or she needs to direct the jury in a way that's consistent with Article 10. And it's the last of those that's, the most practical and the easiest to get over the line, and that's what happened in this case. And
so I heard that Jamie Michael had gone out for a cup of tea to await the verdict, and it was still hot by the time they came back. So, how pleased and how surprised were you at the jury's 17-minute return?
Yeah, well, I was delighted, obviously. And, I was surprised to an extent because jury verdicts don't usually come back that quickly. But I felt vindicated, to be honest. I took the view at the beginning that this was a weak case and that we were going to win, and sure enough, we did.
And so this is, of course, one case that was able to come to jury trial. But one notable feature of his case is that he was held at first on remand for 17 days.
It was actually a bit longer than 17 days in total. That's the figure that was that's been reported. But if you add up the bit at the police station, the magistrate's court, it was a little bit more, I think.
Right. Okay. And I mean, that's unusual in itself, isn't it?
Well, to remand someone in custody, a court has to find that there are substantial grounds for believing that there will be further offences committed. There are other routes to it, if they think the person's going to abscond or they need to be remanded for their own protection. But in a case like this, the big question is, are there substantial grounds for believing that the defendant will commit further offences? And that's, a fairly sort of vague idea, right? It confers a great deal of discretion on the court that's making that decision. There isn't much in the way of appeal rights against that decision in the Crown Court, right? You can ask the Magistrates Court, you can ask the Crown Court, but once they've properly said no, that's it. You don't have a right of appeal to the High Court as you used to many years ago. You can appeal by way of judicial review, but that is a very high bar and extremely difficult to achieve. You would have to show that the decision was one that no reasonable judge could have come to, and so on and so forth. So that's all but impossible. So what was happening here after the riots was that people who had posted things on social media that were taken to be, and not necessarily in fact were, but taken to be encouraging of the riots or supportive in some way, were arrested, and then a bail decision is made. I think it is fair to say that significantly harsher decisions were made about bail for many of these defendants than would normally be made in the usual course of things. Now, there is, of course, some justification for that, right? If there's riots going on, then, people who are going to foment further riots, there's a little more justification in remanding them in custody to prevent them from doing that than there might otherwise be. But there were some, I know of one or two decisions to remand someone in custody where there was next to zero chance that there would be any further offences. People who were just, law-abiding, no criminal record, nice, decent people, were horrified by what happened in Southport, wrote something in a state of high emotion that they would have been better advised not to write. And then when they realised that they were in trouble, delete their account, not go near a computer. It's just not going to happen, right? There were people who were not going to do this again, but who were remanded in custody. And that is not a great thing for free speech. And that led to, I believe, some people feeling that they had no hope and they just had to plead guilty.
And so what is somewhat unusual about Jamie Michael is that he was able to get bail. And do you have a sense of why that is? Whereas, many others in this situation didn't.
Good question. I don't, actually. I wasn't involved in Jamie's case at that time. He was remanded in the Magistrates Court, and then he made an application about 3 weeks later and was successful. I don't know the ins and outs of why he was granted bail when others weren't.
Right. Okay. So, it seems like a very significant part of...
I should say, sorry to cut across you, Laurie. It probably weighed in the balance to some extent that what he said in the video, to put it simply, wasn't that bad. I think people who were, posting pictures of burning mosques saying, come on, lads, etc., were perhaps rightly not being given bail, but Jamie's video is a million miles away from that sort of thing. So I would have thought that in the usual course of things, he would be looked on more favourably from the point of view of bail because of the relative inoffensiveness of his video.
Well, it seems to me partly that, so there was a petition for his bail, which got a few thousand signatures. So it seems to me that partly it was because he was a well-known figure in his community that he was able to make that happen. Whereas, for instance, someone like Cameron Bell, who's a particularly interesting case here, I don't actually know if she did apply for bail, but she certainly didn't get it. And I'll just describe it to you briefly. So she, after a riot in Tamworth, had gone around the town filming a TikTok live stream with a group of other people, some of whom had weapons, but there was no violence that took place. And she had described migrants as tramps in that live stream. And for this, she was indicted for violent disorder and remanded immediately. And not only was she not granted bail, she was only able to plead after a month of being remanded. And at that point, she was advised that were she to plead not guilty, she wouldn't face trial until May of this year. And so she then pleaded guilty and was out in November, I think, having been sentenced to 9 months. But so my question to you is, do you think having been held on remand in this way led to unfairness in the case of someone like Cameron Bell?
Yes. Well, there's an inherent unfairness in the absurd delays that face anyone caught up in the criminal justice system now. I remember in 2007, I went on holiday to Argentina with a friend, and I was in Buenos Aires, and I went to a courthouse there to see what criminal trials look like in Argentina, and I got chatting to a lawyer, and he explained to me that in Argentina at that time, defendants would be remanded in custody and they'd be waiting for 2 or 3 years for their trial. And I couldn't believe it. I felt genuinely scared. I felt, I didn't feel comfortable being in a place where something like that could happen. And here we are in the UK, less than 20 years later. Custody cases are dealt with more swiftly, but if you're on bail, you can be waiting 3 years easy for your trial to come around, if not longer. Trials are being listed now, 2028 is not an uncommon date for a short trial. It's absolutely horrendous. And to think that Keir Starmer, former barrister, defence barrister, former DPP, is presiding over the continuation of that utter national disgrace and embarrassment makes me very angry.
And so there's obviously the issue of the backlog, which is a problem in itself. But with respect to Southport in particular, there's the question, as we've already been talking about, over whether these people should have been held on remand in the first place. And do you think, that blanket remand policy led to some miscarriages of justice, where people who, if they had been able to go to a trial like Jamie Michael, they would have been found not guilty, instead found themselves pleading guilty?
Yeah, undoubtedly. The decision whether to plead guilty or fight a trial is, always a difficult one, including for innocent people, of course. You might not want to risk rolling the dice, even if you're not guilty. But yeah, to a certain extent, in an ideal world, there would not be any discount for pleading guilty. You just have your trial straight away, and it would be determined whether you're guilty or not. I suppose you'd always want some sort of discount for pleading guilty, but you're often defendants now are often faced with, as many of these defendants you're talking about were, faced with a very difficult decision whether to gamble, spend a load of time in custody, possibly then get a much greater sentence, or fold, take it on the chin and sign up to hopefully, only 6 months or something. It's not an ideal feature of a criminal justice system to force defendants to have to analyse gambles like that.
Okay, so it's obviously stirring up racial hatred that Jamie Michael was charged with, and that's different to the lesser offences under the Communications Act, which also apply to online offences. And in fact, stirring up racial hatred offence can merit up to 7 years in prison. So it's very serious. And it's interesting to note that it was the currently embattled Attorney General Lord Hermer who was the one who advised Starmer and others during the riots that this offence could be used against online speech. But, well, I suppose, what have you made of that from a free speech perspective? And, I mean, personally, I don't really agree with any of these offences. But was it the proportionate offence to be using for these kinds of comments online?
Well, it's perfectly okay to use that offence if it applies properly to the facts of the case, right? I mean, stirring up racial hatred is in some ways quite a broad and vague concept. Racial hatred is defined in the Act in a way that is much broader than the words would suggest. So it's really any group that is defined by reference to nationality, race, ethnicity, and so forth. So, foreigners in general, etc. It doesn't. The group doesn't need to be. It doesn't need to be about race, right? But it's stirring up, likely to stir up. There's two ways of committing the offence. One is intent to stir up. The other is likely to stir up. And stirring up is not defined further in the Act or in the case law. What does it mean to stir something up? I mean, in my submission to the jury in the trial, I think stirring something up requires creating something that didn't previously exist. But others might take a different view of that offence, right? If you stir up, take a different view of that phrase. If you stir up a muddy bucket, let's say, the mud's already there, it's at the bottom, and you stir it up and then it goes everywhere. You're not sort of creating mud when it wasn't there before. So the difficulty is, imagine, you don't need to imagine, there are some thuggish, racist psychos knocking around, right? And they might see the message you put on Twitter. If that message is mildly anti-immigration, let's say, those people, on one view, might feel, reading it, slightly emboldened in their racial hatred, right? You're not really creating racial hatred where it didn't previously exist, but it could be said that by posting your mildly anti-immigrant tweet or Facebook video or whatever, you could be stirring up, or it might be likely, if enough people see it, that you're stirring up racial hatred. And I think it would be better if that offence was drafted in such a way that it was incapable of catching those kinds of posts, right?
Yes, and it's something I've thought about quite a bit, actually, because it's, as you say, it's unclear, and it's a metaphor applied to society at large that requires a very specific interpretation of what hate means and what the general level of hate in society means. And I suppose, given how broad and vague it is it not a law which is therefore liable to being interpreted in a way that's tyrannical? Yes,
and we've relied on, for a long time, we still rely on sensible charging decisions. And we hear this the whole time in Parliament, of course, when objections are made to, the drafting of new criminal offences. Well, hang on a second, the way it's written there, doesn't it cover X, Y, Z, totally acceptable behaviour? And the answer so often comes back, oh, yes, of course, but, those people aren't going to be charged. Well, they might not be now, but further down the line, they might. I think it's, I wasn't, I've only been at the bar 20 years. I wasn't practicing in the 70s, 80s, whatever. But I think it's probably true to say that the threshold for prosecuting under that offence has become much lower now than it was in the past. I mean, if you look at the old cases, that have been reported. They're, just completely lunatic, lunatic stuff. And we're now seeing people being prosecuted for things that are not lunatic, that get said a lot by reasonable people, including politicians and so on.
Okay, and so finally, to bring this back to the actions of the government last summer, and in particular Keir Starmer, so he said that it was clear that violent disorder we were seeing had been whipped up online. And, there was this general hysteria about online speech with things like the government's Twitter account saying, think before you post, and all other similar things. And so do you think that contributed to charging decisions that were then made?
Yes, I'm sure it did. I think when bad stuff happens, we like to know why. We don't like the idea that bad things happen in a way that we can't necessarily explain and in a way that we can't control. Right, this is sort of just human psychology. And so riots, terrible riots, that's obviously terrible, obviously needs to be stopped. The idea that this is being caused by, a broad spectrum of policy decisions over a long period of time is an unattractive idea. And so it's much more comforting psychologically to say to ourselves, well, this is all because of, keyboard warriors on Facebook. Can we really say that the riots in the days after Southport would not have happened had people not posted angry stuff on Twitter and Facebook? I'm really not sure we can say that. So although obviously encouraging rioting is criminal and must be treated as such, prosecuted, etc., was there an overzealous approach to online communications in the wake of Southport? Yes, I think there probably was.
Okay, well, Adam King, thank you very much for coming on The Sceptic.
Absolute pleasure. Thanks, Laurie.
Now, just what is going on in German politics? For years, the establishment parties have zealously policed a cordon sanitaire against the radical right AfD. But with an election looming, the centre-right Christian Democrats stepped over it last month when its anti-immigration motion in the German parliament was passed with AfD votes, upending the German party system. And to discuss that, I'm very pleased to be joined once again on The Sceptic by Eugippius, the author of the Substack Eugippius, A Plague Chronicle. Welcome to The Sceptic, Eugippius.
Thank you so much for having me. Always a pleasure to be here.
Yeah, good to have you here. Okay, so we're going to get into the nitty-gritty of German party politics today, but obviously the main issue that is on the table here is immigration and policy towards it, and that's been a huge issue in recent years in Germany. And so tell us a bit about that, remind us of that. And in particular, there's been recently this awful attack in Magdeburg at a Christmas market, and it was obviously linked to immigration. And, tell us what the political reaction has been to that.
Yeah, so migration has become a huge problem in Germany for really two reasons. One is the domestic security situation, which has suffered enormously in the face of, mass migration from the developing world, and the other is the extremely stretched resources at the levels of state government and district level government. So migrants, they receive social services and welfare and housing all at the expense of the state, and there's the resources for this are ever tighter, and the state is really at its absolute limits here, trying to account for them, and has no means of really steering or mitigating the flow of migrants because of the entire EU overlay, asylum, all of these constructs. So both of these are issues, and since May 2024, we've had a series of stabbings, terror attacks in Germany that have made migration just a central political issue. So in May, there was the Mannheim stabbing at a counter-jihadist event where an Afghan migrant killed a police officer by stabbing him in the neck. In August 2024, we had the Festival of Diversity stabbings, ironically, in Solingen, where it was, I believe, a Syrian migrant there who stabbed to death 3 people and wounded many others. Then in December 2024, there was, of course, the Magdeburg Christmas market attack, where a Saudi migrant to Germany, actually a psychologist, rented a BMW and drove it through a crowd at the Christmas market in Magdeburg, and he killed 6 people, including 1 young child, and then wounded almost 300 people. Really, with the turning point was Solingen in August 2024. That's when the CDU, centre-right party, really started.
That's the end of the free part of the podcast. If you'd like to listen to the bonus interview, you'll need to become a regular donor to the Daily Sceptic. For as little as £5 a month, not only will you be able to watch or listen to the whole podcast, you'll also be able to access articles behind our paywall and join our discussion forum on Discord, where you'll have an opportunity to discuss the latest content on the Daily Sceptic with other donors, members of the editorial team, and some of your favourite contributors. Once you've become a donor, log in to the Daily Sceptic using the same email, and you'll find a link to the premium version of the podcast on the homepage, including instructions about how to listen to it on your favourite podcasting app. Remember, you can access all this bonus content for as little as £5 a month. Just go to dailyskeptic.org/donate.